Welcome to our channel. Today I will be discussing with you whether COVID-19 pandemic excuse you from your contractual obligations. First off, a little bit introduction about our law firm and myself. We are a boutique law firm in New York and California. We concentrate our practice on corporate law, intellectual property, and business dispute resolutions. I am a corporate lawyer and I focus on corporate governance, mergers and acquisitions, commercial loans, joint ventures, and commercial contracts. So first off, is the pandemic a force majeure? I would imagine the plain meaning of the word force majeure or act of God means that it is a force majeure event. But does it excuse you from our contractual obligations? Well, it really depends. If the contract itself has specific stipulation, then you follow the contractual provisions, right? Stipulations covering a pandemic. A lot of contracts are primarily concerned about this kind of events. For example, your insurance policies, right? It will say, if this happens, if this unlikely event happens like fire, earthquake, then the insurance company shall pay you that much, right? In consideration for all the premiums you have to pay me, right? But if the contract has no provision specifically covering a pandemic, then gap filling need to be performed to interpret the contract. And a lot of contracts, at least the sophisticated business contracts, have a definition for force majeure or act of God, but you may be surprised to find that most of them actually do not list pandemic, epidemic, or public health crisis there. The definition of force majeure usually has specific events listed there. So what does it mean to fill a gap? It means that the law should fill in the gap left by the ambiguity or absence of clear contractual provisions, setting forth the rights and obligations between the parties. Essentially, how do they allocate the risks and the damages caused by the pandemic. And the very famous case law was Taylor versus Catwalk. It was a very old case. Catwalk and Bishop was the owner of a music hall. It agreed to rent it to Taylor and Lewis, another company, for £100 a day for 4 concerts and events in the summer of 1861. But before the first concert could be performed, the music hall was burned to the ground. And it was a lease, but the judge ruled that it was essentially a contract. And there was no provision there addressing this unforeseen event. That is what happened to both sides if there was a fire, making it impossible for the landlord to lease the music hall to the lessee. Except toward the end of the lease, there was this, good old-fashioned phrase that God's way of permitting us to perform our respective obligations in a foregoing contract, right? And so the plaintiff sued the music hall owners for breach of contract, essentially for failing to make the music hall available for them to host the concerts. You can imagine that the plaintiff had incurred a lot of expenses to prepare for 4 days of concerts and events, and therefore suffer from the economic loss. So the judge ruled that absolute liability should only attach to parties to positive, definitive contracts, and not to parties to a contract that there was implied and essential preconditions underlying the contract. And what does that specifically mean? It means that when the existence of a particular thing or particular kind of external condition is essential to the performance of a contract, and the thing or precondition was destroyed, right, by no fault of the party selling or providing that thing, then both parties are freed from the obligations of the contract. Essentially, the judge was saying they did not have a meeting of mind between the owner of the music hall and the lessee. In the event of a fire, they did not anticipate it, they did not discuss about it, they did not negotiate about how to allocate the risks, the damages caused by such an event. So they did not mean to, have a contract if that event occurs. And the absence of this kind of, special occurrence was the precondition of them to continue to perform their respective obligations under the contract. And initially, the bar was pretty high. The parties that failed to perform the contractual obligations need to meet this standard of impossibility. Then it gradually came down to this standard of impracticability. And there are three parts to the modern rules. The first part is the essential precondition, meaning the parties to the contract relied on a certain assumption with respect to a precondition for the performance of the contract. The very existence of the music hall, right, is the precondition. And the contract, the second part is that the contract did not specifically allocate the risk in the event this kind of preconditions is no longer there, right? Meaning the music hall was burned down, right? So, and there was this special occurrence, and lo and behold, that music hall was burned down. Nowadays, it's no longer sort of impossible, but it says if it's impossible, if it's impractically difficult, given the time constraint and other factors, right, or prohibitively expensive for one party to perform the contract. So you can see contract, has to be, for lack of a better word, reasonable, right? And be smart so that it does not impose a draconian responsibility or cost upon one party. It's no longer rational, right? So nowadays, what are the practical tips giving the legal principles, right? First, if you are a party that has contractual obligation that you have difficulty meeting now because of the pandemic, you want to sit down with your lawyer to actually review the contract. And by the way, you may also want to pull out your insurance policy to see, as I alluded before, whether you have any kind of coverage there for the business interruption or loss of revenue caused by the pandemic, right? And you will also need to establish the cause and effect if you are to, whether in negotiation or lawsuit, right? Try to get out of the contractual obligation, right? So you need to prove, as a matter of fact, to what extent the pandemic caused your inability to perform. For example, could a restaurant now refuse to pay the rent to its landlord? Maybe you should have a better argument in the absence of clear contractual provisions, right? Then, for example, IT consulting company, because because of the lockdown, right? A lot of restaurants could not operate, and they, other than limited nowadays outdoor services, right? So their revenues are dramatically reduced, made it almost impossible, impracticable for them to pay the rent, right? But in the case of an IT consulting company whose work could be performed remotely, it may suffer some kind of reduction of revenue, or it may have increased its, revenue, right? But in the event it has a reduction of revenue, it becomes a matter of degree, right? And does that meet the bar of impracticability, right? That's a factual issue. And you would also want to explore mitigation measures. Modern contract law does impose the duty upon both sides of a contract to mitigate their losses, their own losses. And so here, right, could you incur additional reasonable cost, but still perform your contractual obligation, right? So it's related to the point above. And also, you need to communicate with your contractual counterparty and such that nobody will be surprised, and both sides could prepare for any kind of mitigation or compromise, right? And in the case of a restaurant owner who has rent to pay, right, you may also consider a bankruptcy to discharge the debt, or you could use that as a threat when you negotiate for a compromise. Of course, unless you're personally guaranteeing the obligation under the contract, right? Then do you really want to consider personal bankruptcy, right? So those are the kind of tips that you may want to think about if you are evaluating your contractual obligations under this pandemic. This is today's topic. Thank you for your time. If you're interested, you're welcome to subscribe our channel. Thank you.